And we are live. Hello, everybody. Thanks, everybody, for joining. We are back with another episode of the TRoman Show after a break due to religious holidays, Jewish holidays. And last week we had Halloween, so we all have enough horror in our lives. Decided not to add another show on top of that. But I see that people are joining, so thanks, everybody. I want to welcome my co-host, T. Matthew Phillips, all the way from Nevada, right? You're still there. And we have a wonderful guest here. He's back, James Kelly, Jim, as we passionately know him, who was a couple times before, probably the topmost expert within the prosec community in the United States, certainly on the topic of cameras in court. The leader, the person, the authority, the expert who established the Cameras in Court Now Facebook group, which is very popular. I think you crossed the 1,000 members threshold, right? And wanted to touch base with you. We wanted to cover your most recent federal lawsuit that you filed following your incarceration. But maybe instead of me summarizing the story, Jim, you're beyond eloquent, so maybe you can tell us the background and where things are today. Thank you.
Well, thank you very much for that warm introduction. Thank you for having me on the show, Roman. Thank you, T. Matthew Phillips. Mm-hmm. And, I'll give you a little bit of an insight as to how the suit came about. First, I was arrested. I was actually remanded.
I think that emphasizes, it's kind of an illustration of what happened to to Jim. So maybe I'll fill the black void now. But Jim will be back before long. We'll bring him back. There's always. Oh, you're here. Okay, excellent. So yeah, I think we cannot hear you, James. There's no sound. No sound.
Okay.
Which is again, that's not an illustration. That's how when you throw in a sound.
Cannot hear you.
There's no sound. You can log in, log out, and we'll bring you back in if you want. But yeah, Jim was on the show. We covered the story when he was arrested initially. We covered that with Tracy Arms, another brave parent. So Jim acted as a paralegal in her case, and he was summarily arrested on the spot by the judge, who was very much concerned with him recording. Let us bring him back. And
I do apologize. I thought I had blocked everyone from calling, but apparently I was unsuccessful with that.
You are popular, so I did a rudimentary introduction on my own, but please continue. So you were remanded, you said?
I was remanded. Now, I didn't just go into a court and take out the phone and decide this is a good courtroom to record it. Because that would have been a First Amendment issue, and I don't go into court based on a First Amendment issue. Now, they like to look at it as a First Amendment issue, but that's not how I argue the point. I start by working either for myself or on behalf of a client under the absolute right to procedural due process. That I have a recording device on me, well, that's protected by the Second Amendment. And
Yeah,
everybody gets anxious once I say Second Amendment.
brilliant.
And then we get to the First Amendment issues. But in this particular court case back last December, this judge didn't even allow me to be heard defending my position. And he was required to do so pursuant to the rules of New York State, specifically 22 NYC RR section 701.2 sub C. And of course, let's not forget my absolute right to procedural due process to be heard. There's only three elements: the right of notice that he's going to put me in jail, the right to an attorney, well, I didn't get that, and the right to be heard. I didn't get that. So he remanded me for 30 days. There was such a hue and cry. The phones rang off the hooks, and I've got to thank so many people for that. That they said, let's get this guy out of jail. Besides, if we keep him in, he might start teaching. And we don't want that. So they try to intimidate me by threatening me with jail. That doesn't work with me. I'll walk right in. I told the court officer in advance that I wanted to give her a couple of days' notice, but unfortunately that wasn't going to happen. I filled out and filed the correct paperwork, both with the clerk for the court and in the courtroom for audiovisual application, although that should not be, you never need to apply for the absolute right to procedural due process.
Mm-hmm.
There is no greater public good that can prevent you from having that.
Mm-hmm.
And the courts fear, more than anything else, they fear the independent preservation of evidence of judicial errors, judicial misconduct, and high crimes and misdemeanors.
Good point.
And that's something that would be inherent in what I was doing. So they're afraid of letting me talk because I'll articulate certain points that will put them in a situation where they cannot prevent me from recording. And so the only way they can get me out is, okay, put the cuffs on him and get him out of here. My response, thank you, Your Honor, in just that tone of voice. Now, of course, I'm suing them. And there's the thought that, well, you can't sue a judge because the judge has immunity. Interesting catch. And T. Matthew Phillips, you can probably speak to this. If a judge operates in an administrative manner, then they are liable to for suit.
Mm-hmm.
And that's exactly what the judge did by depriving me of my right to be heard. There was no hearing, made it administrative. So this is making its way through the federal court now. I was expecting that I was going to get a Rule 12B motion to dismiss in writing from the Assistant Attorney General. That's not what I got. What I got was a request, a 3-page letter requesting a motion to discuss Rule 12B.
Very interesting.
Yeah, I didn't expect that. That was a curveball. And so I'm glad I waited to speak on it. But now that I've gotten that, I turned around and I said, well, I'm opposing that. I wrote a letter that articulated my opposition because I was being prejudiced in certain ways. And the Attorney General brought up broadly 2 points. She brought up immunity, and I argued back. and she argued that there was that there was probable cause, and therefore there's no cause of action. Well, in order for there to be probable cause, there needs to be a reasonable
Oh, I think we
Yeah, James is a popular guy.
yes.
So I think he got a call, and we tried unsuccessfully to block incoming calls. But I just want to acknowledge those who were here on the stream. Jenny and Ethan are here. It's a power couple from upstate New York. Thank you very much, guys, for being here. Eric Stone, thank you for joining as well. Deborah, we see your question. I think it's a more elaborate question. So, and then Jenny's asking a question. What was the emotion? But let me bring James back in.
I apologize. It was another call.
Yes.
In order to have probable cause, there needs to be a reasonable articulable suspicion of a crime that has happened, is happening, or is about to happen. Well, the only articulable suspicion that could exist would be that I was going to violate New York State Civil Rights Law Section 52. And the violation of such would be a Class A misdemeanor. The only Class A misdemeanor that applies is New York State Penal Code Section 215.50 sub 3, second degree criminal contempt. And unfortunately, I wasn't the first person in New York State in a courtroom to get hit with that charge. I was looking forward to it. It didn't happen. Someone else did, but there is a federal case running on that right now. At any rate, that would have been a possibility. However, it has no legitimacy, and here's why. New York State Judicial Law Section 750 A sub 6 sentence 2 prohibits the punishment of contempt for the publication of a true, accurate, and complete report of what transpires in the courtroom. And that goes back to the people, ex relation to Barnes, versus the Court of Sessions of the County of Albany, 1895, which is still good case law in New York. That was a case determined by the New York State Court of Appeals, the highest state court. So they really don't have the power to punish me for contempt.
Or could I interject a question here? Just a 20-second timeout on the court. But could they have done something more akin to a traffic stop where they had you sign, for example, a promise to appear, and then rather than be incarcerated on the spot, you could have appeared in court and made a case, 30 days, 60 days later? Would that have been an option, or why wasn't it an option?
Well, that's an excellent question. That should have been an option. Removing me from the courtroom should have been an option. The judge did not go with the least option that he could have. He went with the strongest option. And that's basically because I directly defied him to his face. I think he took it as a personal insult.
So it's a government classic government intimidation to go jump right to the
tyrant going to behave as a tyrant.
That's precisely right. Jim, before we go forward with your wonderful summary, Jenny has a question. If you can please clarify, what was the motion that the government responded with?
What was the motion the government responded with?
Yeah, when they scheduled the hearing, right? So that there was the motion. That's what they requested. The answer in paper.
By letter. They requested by letter. I responded by letter, and the judge hasn't weighed in on it yet.
Okay, excellent. And I know, just for the benefit of the audience, and thank you very much. I see the count of people who are viewing is going up. So thanks everybody. Please share. We try to hold this live stream every Thursday, with some exceptions, but thank you for your patience. So I know that everything that you basically file or receive from the court is under the files folder in your Facebook group, right? Cameras in Court. I believe that you're
It's on Pacer, but I also make it available to Cameras in Court now.
right. No, some people don't have Pacer. Some people are just download too much and then they get blocked, right?
Mhm.
So much for the free access to the courts. So your new lawsuit, right? And the government response is there.
Yeah, it's all there.
Well,
Excellent.
if I could chime in real quick, and I didn't mean to interrupt you, I just had to say, I just have three words to say here: uninhibited, robust, and wide open. That's the language from the Supreme Court case, New York Times versus Sullivan, the 1964 case, which says we have a right to criticize public officials, and the scope of that criticism: uninhibited, robust, and wide open. I feel like I wanted to interject. Please forgive me for the interruption. I feel better now. So, anyways.
No, there's no need to apologize there. In fact, I'll see that citation and go back to Craig v. Harney, 1947. That which transpires in the courtroom is property of the people. If it's the property of the people, then the people can record it.
Yeah. I want to acknowledge the audience again. Holly has a comment saying that's retaliation. Don't you dare exercise your rights in their courtroom. So that's my key subject that I like to pontificate on. But it's all government oppression and tyranny. So we can file beautiful lawsuits. Essentially, we have three people now on this wonderful live broadcast, right? Who have legal experience, extensive legal experience. I think probably decades of experience combined, right? And they still don't care. Because if you're a tyrant, right, you will decide whatever you want because you have the pen. But and we go to that, James, you're getting a lot of compliments here. People will probably reach out separately to you, given your expertise. Now, I have a couple of questions just to clarify. So, you have a judge assigned already, right? Can you share
Oh
who
yeah,
it is?
yeah. I've been before her before, Judge Azrak.
Mm-hmm. So you essentially are chained to the same judge. That's what happened in my cases in Eastern District of New York, right? So all your cases as pro se are routed to the same jurist.
Correct.
Mm-hmm. And when you say that there was somewhat of a curveball, right? What you mean is that in your prior lawsuits, what eventually or not immediately happened, right, is a motion to dismiss. So that didn't happen in this case.
Correct.
Mm-hmm. How do you explain it, and what is your strategy based on that, or tactics rather?
How do I explain it? I really don't explain it. It's just like, okay, let's go with this. Instead of having 30 days to respond, I had 7.
Mm-hmm.
So it limited my access to Westlaw to be able to challenge what the Assistant Attorney General had written. And by the way, what she had written, what she had cited in terms of case law, not a single piece had been reviewed by any appellate court. So that was all case law by the appellate. And notably, of the 5 or so, or maybe it's 6 cases that were cited, 2 of them were so old as to have been before New York State Civil Rights Law Section 79P, which gives us the right to record any kind of executive officer. Now, bearing in mind, peace officers are specifically listed in Civil Rights Law Section 79P. And that's important because there's no courtroom in New York State that you're going to go into that doesn't have a court officer in there who is, by definition, a peace officer performing their duty. Well, now I have the statutory right to record in that courtroom. In addition to having the immunity for making the recording.
Yeah, Jenny's saying that the New York Attorney General is definitely not caught up on case law, which I assume that Jimmy would concur with this opinion. What I, if just to chime on that, so she brought the old case law, right, which was not challenged all the way up the chain of command of the judiciary. Now, again, going back to more I would say philosophical or government structure or tyranny issue, it means that not enough people are challenging this tyranny. Would you agree with that?
I wouldn't necessarily agree with that in this case because this is just, to my mind, a sloppy way to write a challenge, or maybe there wasn't the case law there in the appellate to be able to substantiate her opinion. So she was using just from the trial courts, and in fact, some of what she had used was not even well settled. So I found that to be disturbing. Let's put it this way: me as a pro se, I look at what I'm going to cite as case law. I make sure that it's precedential. I look at the Supreme Court. I look at the Second Department. I look at the New York State Court of Appeals, the appellate departments, and I like to make sure that everything is in line. And I will occasionally, in the rare instance, quote something from a trial court, but I don't like to do that. And I will always shepherdize and make sure that what I'm doing is well settled.
Yeah, we know that you are a very thorough pro se litigant. Sorry.
Right. To find the Assistant Attorney General didn't was relatively shocking. And I did throw that criticism out for the judge to see.
Are they, if I could interrupt, is the government arguing that the judges are not executive officers? Is that the argument?
No. They are arguing that the judge, because they're a judge, has immunity, and that the court officer that did the arresting had probable cause. Therefore, they have quasi immunity.
Okay.
Okay, now, so the judge is named in the lawsuit, right? Personally, and
right.
I assume individual and professional capacity, right? Now, this is not your first iteration, so to say, with the federal court, and if it was a slightly different topic, or the of course different circumstances. Right now, your liberty, your physical liberty was deprived, was taken away from you, but. You filed, I think, basically two variants of the similar challenges to the judicial system, right? Both individual and also against the OCA, the Office of Court Administration. And the games, and in one of the cases, I think the most recent one, before the current one, you went all the way up to the Second Circuit, right? The federal appellate level, and they used both arguments essentially, the both individual immunity for the judges, right, and also sovereign immunity for the entity. So. What was the iteration right now? What is the legal, argument or theory? If you changed anything, if you can explain it in simple or simpler way for the audience who is new to federal lawsuits.
Their argument was that by suing the OCA, I was essentially suing the state of New York. Now, the appellate arguments, I was focused on that it ought not have been summarily dismissed without notice, without hearing, and without leave to amend. Because to do it in that manner was to act for the opposition. And Ortiz v. Perez, 1988, was the case law written by the Second Circuit Court of Appeals that was precedential, and they affirmed it 30 times. So in my case, they overlooked both the case law and the affirmation 30 times to say, no, you can't do this. I'm affirming the trial court. Now, I suspect that that's just because I was a pro se.
Do you expect any different now? What the way the case is going?
I'm expecting to end up in the appellate court. I would not be at all surprised. But then again, because this judge has seen me reach for the appellate court without any kind of hesitation and put together articulate arguments, I'm thinking that she might be a little bit more careful.
Okay, excellent. Let's hope so. Matthew, I don't want to subsume the ether here, so please, have any questions for our guests?
I have so much to say here. Could I make a comment on the immunity thing? And I may have brought up this topic before, but one way to get around it, I think, is to raise a consciousness where all the judges, hopefully, and the attorneys and the litigants, so people start to understand that no judge should ever be able to claim immunity to violating the Constitution. I guess if a judge where I'm trying to think of an example, calculating child support, and the judge is, clickety clack on the calculator, and they get the wrong number and they make an error. Well, that's an error. It's like, oops, it's inadvertence. It may have been, a bad case of inadvertence. But the point is, if somebody does something like accidentally, I could see maybe an immunity doctrine. But to violate the Constitution, and it has nothing to do with intent, it has to do only with the fact that the Constitution is the supreme law of the land. And knowing it's the supreme law of the land, how can there be any legal doctrine that could be paramount to that? If you violate it, there's no excuse for it. You don't get to try to say, here's my reason, or no, I'm immune from alleged violations of that. If a person, here's another one too, no judge should be immune to their own oath, because it's not just like the Constitution is sitting out there. The judge and attorneys raise your right hand and you promise to uphold and protect and defend the Constitution. So how can that same judicial officer claim immunity to their own oath? Because they're making an affirmation unto the universe that I'm going to uphold this principle. This makes this country much better than North Korea, because we have First Amendment and ostensibly, and the freedom of speech and freedom of religion and all those other things. A judge can't really say, well, I violated it, but don't blame me for it. If I had to worry about liability, I could never do my job. Well, I have to worry about liability and do my job. So why doesn't the judge have to worry But the point is, another thing is, I have to say, I want to be quick about this, but in the Stump versus Sparkman case, that's the Supreme Court decision that says that a judge has immunity for acts that fall within the scope of their jurisdiction. If they go a little bit outside the scope, they may get away with it. But if they act in the clear absence of all jurisdiction, then they can get sued, and that's another situation where the line is not bright. At what point does a judge act in the clear absence of all jurisdiction? And so, theoretically, if a person really took the modern judicial immunity doctrine to its logical conclusion, the judge could say, the petitioner, respondent will please rise. And then I guess they could just shoot you in court and say, I'm immune. It happened on the bench. It was in the course and scope of my jurisdiction, and they could get away with it. I know that sounds absurd to say, but if you listen to the arguments that they make in support of immunity, it's gone way overboard. And I believe we need a constitutional amendment, or a state by state start having to pass these laws, but we must remove judicial immunity. I'm okay with the type of immunity they would have, for example, for law enforcement. There is some kind of sense to that, but this all-encompassing blanket immunity, unfettered, I can do whatever I want and I know I can get away with it, and I can do it openly and notoriously, I can do it mean-spiritedly, and I can laugh about it, that's really wrong. It's gone way, way too far, and I guess it just hasn't affected enough people yet. But I think we need to really we need to make judges liable. Again, I want to say there must be a acronym there somewhere, but judges need to be liable when they particularly when they violate the Constitution, number one, because it's the supreme law of the land, and number two, no judicial officer or officer of the court should be immune from their own oath. So that's my story, and I'm sticking to it.
All right, I'm going to do that, and I have a very nuanced response to that I think you will appreciate. First of all, I view the Constitution as a revocable trust document. So we, the people, the grantors, are limited to the voters. Any voter among the grantors, because it's a self-executing document. It has the form, the function, and the elements of a trust document. We bestow our sovereignty onto the government and divide it into three branches so that they are competing of power, of checks and balances. and they're to do the business of the people. Now, all officials are trustees of the Constitution who have taken an oath. All people are the beneficiaries, whether or not they're voters. So when you look at it from that perspective, it becomes a little bit more nuanced. Now, let's go back to Stumpy Sparkman. Stumpy Sparkman said a judge shall have immunity unless there is a complete absence of all jurisdiction.
Right.
And then goes on to cite Bradley v. Fisher,
Yes.
1871,
Mhm.
specifically December 1st of 1871. Now, that is a sub silencio opinion for 17 Statute 13, the Ku Klux Klan Act, or the Civil Rights Act of 1871, and specifically the notwithstanding clause. Now, that particular act was a predecessor of 42 USC section 1983. But the difference is the 16 words of the notwithstanding clause were left out. Now, we don't need additional legislation because that legislation is already there right in that notwithstanding clause.
Good point. Okay.
If you really want to look at it closely, you talked about the oath of office. If you look at Ex parte Young 1908,
Mm-hmm.
we're gonna parse that one really closely, because when a judge reaches the age of 18,
Mm-hmm.
they now have their full personal capacity in their own interest, sui juris, if you will.
Mm-hmm.
All right, that's their personal capacity. Up until that point, they were under the care, custody, and control of their parents. But on their 18th birthday, now they're in their personal capacity. It's not until they sign that oath of office, having taken that oath of office, that they have their official capacity. And that official capacity attaches, or excuse me, that oath of office gives them their subject matter jurisdiction, which attaches exclusively to their official capacity, not their personal capacity.
Mm-hmm.
So when you look at Ex parte Young 1908, it says if a judge or if a state official, and in this case a judge, violates the rights of a person, and I read that to be knowingly, willingly, and intentionally violates it, using the protection of immunity as a sword rather than a shield. All right, if they use it in that capacity and violate the rights of those before them, well, now what they've done is they've stripped their official character and done that in their personal character.
Right.
They have no jurisdiction, no
Right.
immunity.
Mm-hmm.
And
It's a very good argument. It's a very good argument, I have to say. Very good.
When I filed this federal suit, I didn't just file it under 42 USC section 1983. I filed it under 17 Statute 13 as well, just because I wanted to preserve that notwithstanding clause. So the legislation is already there.
Yeah.
The Supreme Court has never opined on it. Not once. Not since 1871. And there have been cases that it has been brought before them that they've just sidestepped. So when we say, gee, there has to be legislation, these judges don't follow the law in the first place. If we write law, it's just new law that they're not going to follow.
This is precisely
Unless
right.
actually rise up against the judiciary and declare it has no legitimacy because these judges have no jurisdiction. The very first time a judge violates, knowingly, willingly, and intentionally violates the rights of a person, they lose their jurisdiction, their subject matter jurisdiction. And they have an obligation in New York State to maintain competence in their subject matter jurisdiction. NYCRR section 100.3b sub 1. So when I argued before the appellate court that every New York State Supreme Court judge that has heard any kind of matrimonial matter for parties that have married in the state of New York after June 12th, 1967, and have not struck down the marriage license statutes as unconstitutional, they become an accessory after the fact to the deprivation of the fundamental right to marry. And they've also become an accessory after the fact of the constructive fraud of selling people the right to marry that already possessed it. So now the entire New York State judiciary has no jurisdiction because there's no statutory mechanism for reacquiring it without being voted back into office.
That's a powerful argument.
The entire judiciary is, let's see, there's a Latin name for it. It's escaping me. But
ultravirus, maybe?
No. Coram non judice and bank. The entire New York State, New York State Supreme Court has stripped themselves of their jurisdiction. It's not something I did. It's something they did. All right. So when we get to the second one, you've got Judge Friendly has substantive due process. There's 11 elements. The first one is an impartial tribunal. Everybody knows a judge cannot have an interest in the outcome of the case. Well, the judge is the personification of the state. So if the state has a substantial interest, that's also not, that deprives due process. And Toomey v. Ohio 1927 goes into that in great detail. So to have these federal incentive grants for the collection of child support deprives all due process in all family court situations, be it Supreme or be it family court. So now you've got two sets of judges that have stripped themselves of their legitimacy because they are the personification of the state in the courthouse, and we know everything's going poorly in the family courts, and that's an understatement. But now you've got no legitimacy in either the Supreme Court or that court. Let's look at the third, deprivation of due process. You've got the situation where you have the right to be heard correcting the transcript based on actual evidence, independently preserved. Now they say, oh, you don't have that right anywhere. Well, show me how I don't have that right. In federal court, I can go file an AO 436 form and get both the recording and the transcript and validate them against each other. I can't do that in New York State court because the judges, all of them, every last one of them, is afraid that in any recording, there will be the preservation of evidence of judicial error, judicial misconduct, high crimes, misdemeanors. And they're afraid of that. And quite honestly, the entire New York State judiciary has no legitimacy at all. None. Because they've stripped themselves of their jurisdiction.
Yeah, it makes sense. These, that's again, it brings the point that that's dear to my heart and should be to everyone's heart. That what we're gonna do about that, right? Because what you're saying is a convincing argument, and both from a legal and rhetorical and philosophical perspective. But they have the power. They have the power of the pen. They have the power to ignore the law. They have the power to ignore the Constitution. You yourself, you went all the way to the circuit court, the federal appellate court, and they ignore it as well. So the only avenue of peaceful resistance remaining is the Supreme Court of the United States, and they are very selective about their cases. I think they don't ever take pro se cases. There were just a couple in history. They just pass on them. So
there is another avenue of peaceful resistance. You see, Federalist 29, written in 1788 to the people of New York, said that the people have the right to take up arms in defense of their rights against the tyrannical government and against the rights of their fellow citizens. All right, that's right in there. That's the foundation for the Second Amendment. Now, in let's see. District of Columbia versus Heller, 2008. Or maybe that was Heller versus District of Columbia. I can't remember which, but it was 2008. They went through and they did an analysis of what constitutes arms, and they went back to the dictionaries of the time, and something that can be held in your hand for defense constitutes an arm. Okay, great. Now, Supreme Court decision in Caetano versus Commonwealth of Massachusetts, 2016, discussed, well, a stun gun didn't exist at the time of the signing of the Constitution. Does that qualify as an arm? The Supreme Court says, yes, it didn't have to be in existence at the time of the Constitution. So all recording devices fit that category. They are exclusively defensive arms. I can't shoot somebody and cause a mortal wound with a camera. But, there we go. But I can, I'm going to start my car here. Okay, but I can shoot video and film, and what that can do is that can protect somebody from the erroneous deprivation of rights based on an erroneous transcript. So we can take up arms in the court and defy the court to their face. Now, we'll probably get arrested for doing that. I'm not going to kid you. They're going to try and intimidate you and threaten you and do all of that. But I've done the legwork. And if you're at wit's end, if you've got nothing else left to lose, if you've lost your fear, including your fear of going to jail, well, gee, if you walked into a courtroom, say an arraignment courtroom, criminal proceedings, there's no basis in Waller to close that courtroom. Waller versus Georgia, 1984. So you've got no basis to close that courtroom. If you're operating as a court recording paralegal on behalf of the clients or the accused, just in the hopes that you'll be able to make them clients, just the same way that the defense attorneys do, well, you have a right to be there. And there's a lawful right, so it's not trespassing. It's not the obstruction of governmental administration, because all you're doing is pressing a record button. And that does not obstruct anything. It's not overly burdensome of the courtroom that it would deny due process like Estes v. Texas, 1965. However, you know, they're going to go up in arms if they see you actually recording. And I like to be seen recording, because I'll go tooth and nail with them. If they want to say, well, the judge has discretion. No, the judge has no discretion to deprive the absolute right of procedural due process. Well, you have to ask permission. You don't have to ask permission for the absolute right of procedural due process. But it's a First Amendment issue. And this is not the correct forum. Well, I'll tell you what, it's a Second Amendment issue. Forum analysis is put to the side. Yes, but it's a reasonable time, place, and manner under the First Amendment. No, it's not. That's put to the side under the Second Amendment, too. In fact, the only argument that you have under the Second Amendment is found in Shuttlesworth v. City of Birmingham, Alabama, 1969, which says that you need to have a narrow, objective, and definite standard in order to deprive a First Amendment right. And absent that, you are free to ignore that law. You have kind of a sense as to why they don't want me talking in court.
Yeah, but we have you talking. It's very, very important, very impressive as always. I want to just go quickly through the comments and acknowledge the audience. Mike now is here. Holly is very active. We have very active participation in the comments. I see that people are exchanging information, which is exactly what it's supposed to be. We're providing infrastructure for court victims and activists to connect. Deborah is chiming in from California, so thank you for that. Eric, Bogdan, very active father. So I shared a couple of his posts recently. Walker out. I think we have a new member of the audience. So thank you for that, despite the clear pseudonym. And there were a couple of questions that Jim, as long as we have you here, and Matthew, of course, you. We try not to go over an hour, right? Just based on prior participation. Even though it's again a great engagement, Nicole. Thank you very much for what you were saying. But Lisa, it was Jenny, I believe, who asked if somebody had any experience with oral arguments in federal court. So I did myself during the conference. It wasn't proper an argument, and I think, Jim, that's what the government is trying to schedule in your case. But you did you did have a full blown oral presentation in the circuit level, right?
I did, yes.
So any tips on that? Any anything to share with the audience?
You really want to do your homework. That particular forum is a follow up on any written arguments that you have, and it's to help the judges understand any of the fine points that maybe you didn't make as clearly as they might have liked, or they might have a new question, and put things in a new perspective for you. But or if you realize there's something that
I think Jim's frozen, right? On your end as well, Matthew?
Yeah, it looks like he's frozen.
Okay, so Jim, he probably hears us and we'll reconnect. Now, maybe you can chime in on the question, if you have any tips for presentation. Obviously, you're a professional, but in terms of presentation to federal court, any differences to the state court?
I think there's always a notion that the federal courts are more serious, I guess, and maybe they're more learned. And I guess the federal judges maybe, like, I want to say, a higher quality of judge. It sounds kind of bad to say it that way because, I guess all judges are, professionals. But remember, the federal judges are appointed by the president, so they're kind of 1 degree away from that status of power. And so and I think the federal judges do act more accordingly. They're more professional. They're less likely to get emotional. Some of the things I've seen in family court, particularly here in beautiful downtown Las Vegas, Nevada, these judges, just really emotional outbursts and hollering and saying crazy things. And it really is. I think it's a different mindset, really. And I think along with that, in terms of presenting the arguments, the federal judges are better prepared. I think they're more apt to have a tentative ruling, or if the oral arguments, they'll limit, the scope to be more focused. Whereas in the family courts, for example, I don't think the judges even read anything, and that's only because, not because I'm being negative, but because I had this discussion with somebody. I've just spent so many hours in courtrooms doing motion practice that you really do, as an advocate, after how many, 32 going on 33 years, which judges read and which don't. And I think the federal judges are probably better at reading the briefs than would be the state court judges. I think we have James back.
Yeah. We do. I apologize. My phone overheated. I was trying to charge it.
Makes total sense. And we are basically, we are approaching the end of the live stream. We can always bring you back if you agree. Jim, it's always a pleasure to have you here with your knowledge. So yeah, you kind of you provided your opinion or your input as to Jenny's question on what any tips on the oral argument in federal court, and then Matthew provided his. Now there's one other question that Jason asked, and maybe it actually loops back to the clip that I put at the beginning, right? The elections or /selections. Or the given to my even my bias, my opinion to that. But it's a question that I want to pose to this esteemed panel. If do you expect anything new with the new administration coming in? What's clearly the people who are watching us, and again, thank you, have want to hear what you guys have to say.
Can I go first?
Sure.
I was thinking of the rock band U2, And there's a famous quote by Bono. I'm not sure how to pronounce it, but the quote goes something like this.
Pro
Nothing,
bono, pro bono. You know, it's
Bono, there you go. Okay.
it's
But
a
here's the quote. Nothing changes on New Year's Day. And, it's kind of this metaphor for how, like, despite the fact that the clock has changed, like nothing changes on New Year's Day. Here it is post-election. And okay, wait a second. The stock market's probably more active, but okay, what's different,
Well, the president, Trump, has been through the courts and seen the corruption of New York firsthand. I'm sure it wasn't a surprise to him. But the reality is he's just one person. And it's not up to him to make the change. It's up to we the people. Because we the people are the grantors. He's just another one of the trustees. So it can't be us waiting for him to be the savior that fixes everything. He doesn't have a magic wand. I guarantee you he does not have a magic wand. At least not one that works. So it's until we do something about it, until we say these courts are not legitimate, these courts are not providing due process, these courts are no better than the Star Chamber courts of 1640, when they were disbanded by the Habeas Corpus Act, and we're not getting due process now, just like we weren't getting due process in 1215 when the Magna Carta was signed. Right. So it's now up to us to go in and hold the tyrants like King John accountable. And okay, so I'm not so good with a sword. I'm much better with a camera. and I'll walk into a court and that's my weapon of choice. It's a camera. So just like you wouldn't take a knife to a gunfight, you don't take a gun to a camera fight. Mm-hmm. And that's the reality. That's me facing off with them. And when I show people this over and over again, and I go and I put the legal arguments together that support what I do, and I need to do a little bit more in educating people. But let me ask you a question, T. Matthew Phillips, if I can. Mm-hmm. From what I said before, do you have any disagreements with it?
I think your arguments are brilliant. I think you're well spoken, and I'm dialed in.
Okay. And what would you expect a judge to feel about my arguments if I walk into their courtroom and set up my recording equipment?
Well, it depends. I mean, at this point, you would think that, your arguments are spot on. And I think if the judges are being sincere, they're going to follow the law. And to the extent they're not being clear about what they're doing or trying to, upset the procedural due process, it never looks sincere to me. And I imagine the judges would meet you with a certain degree of hostility. But then again, I would also think that they would be impressed by your argument, and they would know that it's kind of folly to try to keep going against you, because that's the thing. You're making the right arguments, and that's the point.
Well, thank you. And we have a couple of unique laws in New York. We have New York State Civil Rights Law, Section 79P, and New York State Judicial Law, Section 758, sub 6, sentence 2. We do have two bills, one that's passed in the Senate, one that has not passed in the Assembly, for cameras in the courtroom. Mm-hmm. And I am a very vocal advocate against those bills, despite the fact that I'm a vocal advocate for cameras in the court. Those bills would codify the unbridled discretion of judges, which is inherently unconstitutional. And that's what they're seeking to do, and put it under as a Trojan horse, like, oh, look, we're putting the rebuttable presumption of cameras in court, but the judge has full discretion.
Well, could I bring up a point here? Sure. Something that I thought was, and I don't know if it's just me, but this is an impression I had. many months ago here in Las Vegas, there was a guy that got vertical. Does anybody remember that? The guy that jumped over the bench to attack the judge, got nationwide headlines, you know.
I was
Um,
impressed by that jump.
I mean, it was a very athletic maneuver, you know. And the the uh, the thing I keep wondering here with these judges is uh, there was a point going back to what you were making on this, and you know what this goes directly to what you were saying.
For once, it's not me.
Well, yeah. Once Timothy Phillips touched the sensitive topic, he got disconnected. But I see a bunch of yeses here in the comments. So that vertical maneuver is certainly remembered. Everybody's saying they're afraid of proselyticans who are capable. So Jim, yeah, while I have you here, I think we would like to wrap up the live stream. We're at the top of the hour, but it comes back, and I want to say, for those who will watch it and those who are with us right now. Well, I see that TMP is back on. Let me add him to the stage. Yeah, you started being controversial there with the description of the vertical flight, and that's
Oh,
how.
I was going to make a. I wasn't trying. I was trying to make a point about something, you know. And now I forgot what it was. It had to do with the portions about. I forgot where we left off. Actually, I'm so sorry.
I had
Yeah.
reminded.
I'm sorry.
I said I had reminded you of something with a comment that I said earlier.
I totally forgot. I'm so sorry here. I apologize.
That's fine. We need to wrap it up anyway.
Okay.
So if I may conclude, Jim, as I say, I think on every live stream that I have the honor of being sharing with you, you were my inspiration, one of the key figures that actually helped me become public, because I firmly believe that that's the only way out of this tyranny. As people who follow me, they know that I was born under communism, and it's relatively rare, even becoming less rare, more frequent, for Americans to understand that tyranny can emerge in every country. And unfortunately, what I see, what I smell, and what I hear around me, that's the same path that this great country is going on. I think the globalist forces will not be successful in doing that, because America is still a very, very strong country, and Second Amendment was preserved, in all its aspects. Um, but there's certainly tyrannical attack from every subverted institution. That's the way I analyze the situation, and at least based on my Facebook numbers and views, many people actually this message resonates with them. I also want to clarify for the government officials who will be undoubtedly watching that nobody here advocates any type of physical violence, right? And the reference to the Second Amendment rather is in most I wouldn't say metaphorical, because it's strict legal sense, right? It is an instrument to curb tyranny, but again, nobody here advocates any type of physical resistance. It's what we need to do is to spread the awareness. We need to speak. We need to present the example, right, of being outspoken and vocal. And Jim, you certainly were my inspiration. Timothy Phillips, it's great to have you. You are an example for so many attorneys, and we try to negate almost single-handedly the image of a corrupt legal profession. But those who are affected by the system, and there are some brave individuals. So I think the bottom line is people need to be brave, right? So what you did, I refer to what you did yesterday on the podcast with Amul's Vision with Tony Patel. That it's a Rosa Parks step, right? It was an action that you simply defied tyrannical government official, right? And you did it without any violence. You just refused to follow illegal orders, and that's exactly what people need to be doing. It doesn't have to be that extreme, right? At least post, share, be vocal, help those who are braver, share and spread the message. Because my honest opinion is at this stage, and I did practice law, and I did file federal lawsuits, and I did fight both pro se and represented in the various state courts in the state of Washington and New York, that legal arguments don't help with communists. They don't care about any law, right? They care about power. So at this stage, and that's my unfortunate, maybe cynical belief, is that whether Trump is in office or whatever, it doesn't really matter. What matters is by legal actions are only, and Matthew will love it, right? Legal actions only matter and bring results in conjunction with publicity. because what we are doing
Yeah.
is showing the public that even somebody as articulate and knowledgeable and erudite as you, Jim, bringing all legal documents, the arguments and memorandums of law, and they still don't care, right? It shows the public, the uneducated public, that still is under the deception that we have courts, we have rule of law, that nothing works. So by using the legal methods, we show everybody that it is still tyranny. It doesn't work. They don't care about the law. It's all a deception. Rule of law, unfortunately, is not a lie. But it's an important part of the awakening. So that's my take on it.
Without due process, we the people have nothing that cannot be tyrannically removed from us. Nothing.
Oh, and I remember what I was going to say now. Can I say it real quick if I do it in 60 seconds? Remember the incident in the Vegas courtroom. I'm not trying to glorify the, athletic prowess of the guy, but the point I was going to make is one thing we learned is that there are more cameras in the courtroom than we thought. Here in the state of Nevada, everything is filmed. If you have a family court hearing, you can just order a thumb drive for like $5-6 and watch the whole hearing. Well, when that incident first happened, a local guy got the courtroom tape, and then put it online on YouTube and probably got millions of hits. But then, I remember I was watching the news here in Vegas, new exclusive footage of the attack. New. I go, what do you mean new? There's the stock cameras in the courtroom. Well, it turns out there's a second set of eyes, or second camera, if you will, when they had actually, I think, well, probably two more. There was behind the judge, there was, and I'm thinking in this day and age, even though they don't allow cameras in the courtroom in New York, the reason I'm saying this, it's so hard to imagine that they're not filming, at least for their own purposes. And they could do an innocuous tiny camera, not a security looking thing to deter would-be felons, but just to monitor and the would-be unobtrusive. I have to believe they're doing that recording. And if they are, if it's a general dragnet style, if you will, recording, it seems to me it would fall in the purview of a Public Records Act or a FOIA type request. And I was hoping to encourage others to make FOIAs for that type of footage. It may be characterized as security, but still I think it should be the property of the people, because we get to see what the people's business in the courtroom. And that was my final thought. So
I'd like to address that for New York. The court found in People v. Sellers 2021, and admittedly this is not but,
Yeah, we have technical difficulties, but might be a sign from above that we need to finish. I want to acknowledge everybody who is here. So, Mike, thank you. Audrey, thank you for joining. Deborah, Holly, those I don't mention. Jason, thank you very much for chiming in. Nicole, saw the comment on Instagram. I think Facebook is the audience. This is the platform that we see the engagement from the group. That the information that we are sharing here is pertinent. Parents of children in the age that are still trapped in the family court system. But to your point, Matthew, they have cameras. There's no doubt about that. In my court in Richmond County, Reichmond County Family Court, the guards lied to my face, saying, "No, we don't have cameras in the court." When I clearly, saw them. So some of them are semi-hidden, some of them are right in your face. Of course, they record everything. I am actually an advocate that we saw a curb in the police corruption, right, or police violence when they were mandated to wear cameras, right? But
yes.
So why can't we curb judicial violence with cameras requiring the judges? I'm only saying it half jokingly, right? So this is the pivotal profession. They embody the government, as Jim referred to, right? And even in their between court sessions, interactions, right? They're prone for abusing the power, right? So why not? Why not require them? And if you can send the heat, don't enter the kitchen, right? So that the same logic should apply to judges. But we are light years away from that. We need brave people like Jim. Jim, we got you back. I think it's a sign from above. That we need to finish. So since you are an esteemed guest, the last words are yours, and we'll say goodbye to everyone and thank you.
Well, thank you. I was finishing on the People v. Sellers 2021, where the trial court said that the court reporters know that the court reporter's recording, if one is made, is their notes and it's not discoverable. So there's no access that they're allowing in New York. New York is
Wow.
probably the most repressive area of courts outside of DC. So unless we do something ourselves, nobody's coming to save us.
Yeah.
This is true. Okay, we have a great comment here from Amul's Vision, saying that you are a hero. I respectfully concur, and you are an example, Jim. I'm grateful for everything that you are doing. Again, you showed me the path toward peaceful, articulate resistance, and publicity. So thank you for that, and I'm sure that so many in America, across the nation, and actually beyond that, are grateful for your activism and bravery. You are the Rosa Parks of our days.
Thank you,
And
and thank you for having me on.
yes. Okay. Thank you, everybody. Thanks, everybody. We'll see you on the next show. Thank you, Matthew. Thanks, everyone.
Take care. Thank you.
Bye.